Good morning, everyone. Welcome to the Joint Standing Committee on the Judiciary. We have 3 public hearings this morning, but we are going to start with committee member introductions. Representative Sato, would you like to begin?
Yes. Good morning, everyone. My name is Ellie Sato. I represent House District 109 in the beautiful town of Gorham.
Hello, I'm Adam Lee. I represent House District 89, which is downtown and New Auburn.
Good morning, I'm Jennifer Poirier. I represent House District 70, which is Skowhegan.
Good morning and welcome. My name is David Sinclair, here for the people of House District 50, the city of Bath.
Good morning, everyone. I'm Dylan Pugh. I represent House District 114, which is part of Portland.
Good morning, everyone. I'm Rachel Henderson. I represent the people of House District 78, which are the beautiful towns of Bethel, Byron, Hanover, Milton, Roxbury, and my hometown of Rumford.
Good morning. My name is Danny O'Halloran, and I proudly represent District 20, the industrious city of Brewer.
Good morning. My name is Ann Carney. I represent Senate District 29. That's South Portland, Cape Elizabeth, and a little bit of Scarborough. And I serve as the Senate Chair of the committee.
Good morning, everyone, and welcome. I'm Amy Kuhn. I represent House District 111 in the town of Falmouth, and I serve as the House Chair of the committee. We're going to start this morning opening the public hearing on LD 2193. This is an act to extend the requirement that the Maine Commission on Public Defense Services compensates certain private attorneys appointed to provide indigent legal services. Well, welcome Senator Carney.
Good morning, colleagues. As you know, my name is Ann Carney, and I represent Senate District 29. And I am very pleased to be here today to present to you one of the bills that we as a committee reported out. As you'll recall, we reported out some legislation in response to the requests of the Commission on Public Defense Services. And we as a committee didn't take any position on the legislation. We simply wanted this legislation to have a public hearing and to follow the legislative path. And so this first bill, 2193, is entitled An Act to Extend the Requirement that the Maine Commission on Public Defense Services compensate certain private attorneys appointed to provide indigent legal services. And so this is basically a reproduction of a provision that had been in law and expired on February 1, 2026. We originally enacted this provision in order to sort out who compensates who in conjunction with cases that judges referred to attorneys. And it was an important step for us to take as the court system dealt with the large list of unrepresented Mainers who are entitled to a Sixth Amendment defense. And while that list has decreased dramatically, there still is a need to have this temporary measure in place. So what this does is it reinstates what had been in place and essentially extends it until February 1, 2028. And I'm happy to answer any questions.
Any questions for Senator Carney and committee members? Representative Sinclair.
Thank you, Madam Chair. Good morning, Senator. So I remember when we were first discussing these same topics in the context of 1101, the question of what authority or ability the commission would have, MCPDS would have to, I don't want to judgmentally use the word audit, but I think that is the intent, to be able to review the invoices submitted by those private attorneys who might be court appointed. And I'm wondering whether conversations have progressed at all, to your knowledge, beyond just identifying that as a risk.
I think that's a question better asked to the director of PDS, but I would say it's my understanding that the attorneys who are referred cases by the court are entered into and become part of the PDS system. And so I think for some purposes, they would be subject to the same kind of review that PDS lawyers would. I know that they're not specifically within the full scope of PDS, but I think it's a good question for the director.
Any other questions? All right, not seeing any. Thank you. Representative Caruso, would you like to introduce yourself?
Yes, I would love to. Good morning, everyone. I'm Elizabeth Caruso. I represent the people of House District 72, which is much of northern Somerset County.
Thank you. All right, is there anyone in the room who'd like to testify in support of this legislation?
Good morning. Senator Carney, Representative Kuhn, members of the Joint Standing Committee on Judiciary. My name is Julie Finn, and I represent the judicial branch. I would like to provide testimony in support of LD 2193. As Senator Carney just mentioned, this bill results from LD 1101 from about a year ago, which was passed as an emergency last session and became Public Law 2025, Chapter 40. And it allowed off-roster attorneys who were appointed by judicial officers in a limited number of cases to be paid by the Maine Commission on Public Defense Services. And as Senator Carney also mentioned, that law is now repealed as it contained a sunset date of February 1, 2026. Also, that law required both the judicial branch and PDS to submit reports about the 9 months or so that that law was in effect. We both did so several weeks ago, and I believe your analyst or clerk or both have passed out those reports to refresh your memory. And what happened when the reports were submitted, the Judiciary Committee ended up reporting out 2 bills, one which contained the recommendations of PDS, one which contained the recommendations of the judicial branch. This is the bill that contains the recommendations of the judicial branch. To be clear, there are a small number of cases in which a non-rostered qualified attorney is available and willing to represent an indigent defendant. In addition, there are qualified attorneys, including former law clerks, who are willing to handle appeals for indigent clients, particularly in the child protection arena. Just this morning, I checked to find out how many of such appeals were pending without counsel, and the number is in the vicinity of 25 to 30. It's not an insignificant number. The number of cases affected by this proposal may be small, but every case for which there is no attorney available involves an individual who matters. LD 2193 is a stopgap measure, as was LD 1101. It is not a solution for the lack of constitutionally required attorneys. As the Chief Justice stated in her remarks just last week, while the number of cases lacking counsel is significantly reduced, it is still unacceptably high. There shouldn't be any. No one should be waiting to have an attorney appointed to represent them in cases in which there are significant rights and liberty interests at stake. Every case matters. Because we all hope the shortage of defense attorneys is a short-term issue, we have again recommended a sunset date. The repeal date of February 1, 2028 is included in the hopes that this law will no longer be necessary at that time. As a postscript to this testimony, we have been working with MCPDS to incorporate the recommendations from their bill into this bill as an amendment, and I hope to have an amendment for you prior to the work session. So thank you very much for your time. I would be happy to answer any questions.
Thank you. Are there any questions for Julie Finn? Representative Lee?
When you say their bill, which bill are you referring
Oh,
to?
2195.
Got it. Thank
The
you.
revisers stuck one in between the 2 bills reported out about counsel.
Other questions? Okay, not seeing any. Thank you.
Thank you.
Anyone else here in the room who'd like to testify in support? Okay, I'm advised we don't have anyone on Zoom right now, so we'll move on. Oh, I'm sorry, Representative Caruso, did you have a question?
I'm not sure, I don't have the paperwork in front of me. Is there a fiscal note yet?
No, not at this time.
Okay.
Right, is there anyone in the committee room who'd like to testify in opposition?
Trying to be organized.
Welcome.
Good morning, Chairs Carney, Chairs Kuhn, distinguished members of the Judiciary Committee. My name is Freyla Tarpinian. I'm the Executive Director of the Maine Commission on Public Defense Services. I'm here testifying in opposition of 2193. I'm not going to regurgitate my 1101 report. I have briefly restated some of the main points in here. The biggest two reasons for opposition currently is, first of all, the authority that was granted in this statute was very little used. And it was used to appoint PDS attorneys most of the time, which is something that we would like to see not happen going forward. Those attorneys could have been appointed to these cases through the regular process, which is what we would prefer to see. The second piece is the list, the need for this, although last year was undeniable. And I completely agree with what Julie Fenn just testified to. The fact that we have an uncounseled list is a problem. I acknowledge that openly, and we're working on it. That list has fallen dramatically. As of today, it's under 125 people and under 150 cases. So we've made tremendous progress. We continue to make progress on this, and we're working very diligently to eliminate that uncounseled list. This authority didn't do much to help. I will say that the protective custody cases were the most benefited the most from the statute, and that list has fallen as well. Happy to take any questions.
Are there any questions, committee members? Representative Sinclair.
I don't know if you, good morning.
Good morning.
I don't know if you heard the question that I had for Senator Carney after she presented, but essentially it went to the question of whether the ability of PDS to keep tabs on the spend on any invoices for those private attorneys who were appointed by the court. I'm wondering if the conversations that the commission and the judicial branch have had, and that we anticipate seeing an amendment before work session, I'm wondering if those conversations address that issue.
It does. The commission's position is based on the authority in here. We don't have audit ability on the cases. Now, it has not been, I provided a report of all of the times we've used it and the amount of money we've spent using this authority. Half of the people who were appointed didn't actually submit invoices. So that's a different issue. We don't believe we would be able to challenge them. We would, in order to do that, they have a right to challenge our audit process and file an ADB action. We would like to avoid future litigation, if at all possible. The bills that were submitted were reasonable and we would have covered, but we don't, if something was submitted that we normally wouldn't cover, I think we would pay it under the current language.
Are there other questions for Freyla Tarpinian? I had a quick question. You mentioned that the numbers are also down in the child protective cases. Are you able to give us any specifics on that?
Yeah, I believe the 25 numbers is actually right on point to what I have as well.
Okay.
That list is maintained by the court, so we get updates very frequently on it. It was around 44 at the end of last year. So it's fallen in about half, and many of those are from the statute. I'll acknowledge that the statute has been helpful in the child protective realm. That is, I spoke at length on that during my report. That is a particularly difficult type of case to staff because of the expertise required to do child protective appeals. You need 5 years of child protective experience, and then you need to have specialized training in appellate work.
Thank you. Representative Lee?
Given that difficulty with staffing the child protective cases, would there be a version of this bill that you could accept that deals just with the extension of this for purposes of child protection cases?
The judicial branch, Julie Fenn and I have been speaking about an amendment that I think neither one of us loves, but we can both live with. Certainly what I've seen so far and what they've indicated their willingness to perhaps go forward with is something that we could live with.
Great.
It doesn't limit it to PC cases, however.
Okay. Would it also incorporate 2195? Was that the discussion?
It would, yeah.
Representative Henderson?
Thank you, Madam Chair, and good morning. I'm surprised to hear that the provisions of 1101 weren't more beneficial to the unrepresented list. Is that how I'm reading it? Is that it seemed to impact it at a very small rate?
I think if you look at the target audience for this for this statutory language is attorneys that are not currently doing PDS work, but who are willing and able to take on either criminal defense work, protective custody work, protected custody appeals, one of these very specialized cases at a much reduced rate from their private pay. So you're asking attorneys in the private world to dedicate some of their time at a much reduced rate. Again, most of them, about half of them didn't even submit invoices to do this work. There's a very small number of attorneys, I think, who fit that bill. The idea that there's a huge amount of this pool of untapped resources of attorneys who've left PDS and have just taken themselves out of the system and are held out over on some island from themselves they don't exist. There are some attorneys who have gotten fed up with PDS. They've left, they've diverted their practices elsewhere. There are law clerks who have left their clerkships and are very capable appellate attorneys who are willing to do an appeal or two because the court is in need, and attorneys respond when asked by the court and by PDS, honestly, when there's a need. We sent out an email request as a major need earlier, I think last week, about Aroostook County, and we've had a tremendous response. They've taken about 50 cases off the list in the last 5 days. So when the court and when somebody stands up and says there's a major issue in the justice system and attorneys are able and willing to pivot and help out, they tend to do so. I don't believe that, especially in the last year with the high number of cases pending, that people have had the capacity to pivot and do so, even though the need was undeniable. Everybody knew.
So, and what we have here is, it looks like a total of 10 cases that were impacted by this provision.
Yes, 10 cases, 11 attorneys.
10 cases, 11 attorneys.
Yeah.
Do you think that, and I don't mean to put words in your mouth, but reading between the lines, between that and then you saying that if this bill were to pass, you would like for there to be notice given to PDS. Do you think that there potentially was more than the 11 attorneys, 10 cases, that there's just some that you don't know about? Or do you think that the number that you have in front of you is accurate?
The number I have in front of me from the cases we're aware of is accurate. We found out about one in the last week that we didn't know about, that was appointed in May of 2025. So one of the issues is we aren't notified when the statute's used. It's kind of in the mix of all the appointments, which makes it difficult for us to track. But honestly, we'll take any help to get cases addressed. We appreciate the efforts that the judicial branch has made. We are concerned about controlling the quality of work and the payment for the work, because that's what we've been tasked to do, and that's what we're held responsible for doing. So if we're paying funds, we have to be responsible to make sure those funds are well spent, obviously. We have to make sure the attorneys are trained. I don't believe this law has done damage to either of that. There's potential. If you're looking for risk assessments, there's potential here that there could be misuse in a case or two, but that has not borne out. We were very concerned about that a year ago. Like, I'm aware of the testimony a year ago. I'm aware of the concerns a year ago. We were very concerned that if there was just anybody being appointed to any of the cases, we would be really worried about those clients and our ability to pay. What's happened has not come to fruit. That being said, we're down to a number of cases that are so few that 10 cases is significant. 10 cases is half the PC list. I mean, that's when we talk about at this point and eliminating that uncounseled list, we're talking about 10 cases at a time. I mean, we're down to the minutia of that list, and then thinking about what does the future look like so that we can get to a place where we're not using a list to staff cases anymore, because we want to be staffing cases at the first appearance. So that's where I know everybody wants to be in that spot, and we're close. So I think looking at the amendment, it's reasonable. We will take any help staffing cases, and particularly PC appeals. I went on about the need there. We are worried about some of the things. We're highlighting the risks, I think, of this going forward, but we're not in a position, to turn down assistance. The court is absolutely working in good faith. They're working diligently. We don't want to be working adverse to them. They care about this topic profoundly.
Representative Caruso.
Good morning. Thank you for your testimony. You have mentioned it a couple of times, and I don't want to assume that I know what you mean, but you have said that there are attorneys who don't even submit invoices. And I was just wondering if you could clarify why that happens. Thank you.
I have no idea why that happens. We are perfectly happy to get work that we don't pay for as long as it's high quality work. But we have, it's in the 1101 report, and in the PDS reports that were submitted earlier this year. In the 1101 report, we highlighted all the places where attorneys we represented. One did not want to deal with getting signed up with a vendor code through the state. That's not a high paper, that's not a very difficult process. It's one piece of paper that you have to submit and the state will not allow us to pay you without it. Others said they considered it pro bono work. Again, when the court makes a request, attorneys take that very seriously. And so I think there was some outreach done for large firms that do not typically take the work. And practitioners who were able to take a case here and there to help staff the cases, which, to be honest, when we had 1,100 cases, was absolutely helpful. Every case does matter. Every person on that list matters. Every case that we can staff is closer to, again, eliminating that list, which is where we all want to be.
Any other questions, committee members? Not seeing any. Thank you.
Thanks.
Good morning, Chair Carney, Chair Kuhn, members of the committee. My name is Jim Cohen. I'm an attorney with the law firm Verrill Dana, and I'm here on behalf of the Maine State Bar Association, speaking in very respectful opposition to the bill that is before you. Our written testimony has been uploaded already, so hopefully you have it from our president, Rachel Okun. But just a couple of quick points. Last year, our association did not support LD 1101, at least the portion that related to having bench appointments. We were concerned about that. So we're back again this year saying a lot of progress has been made since 7 or 8 years ago in what is now MCPDS. And I guess we would encourage that as a state, we should focus on making MCPDS the one-stop shop that can be the place where assignments take place. So that's the first point. The second is we haven't forgotten how not that long ago there was also a problem with the supervision and training and qualifications of attorneys that were in the system. And one of the challenges that MCPDS has been working through is improving the system by which attorneys are trained. So attorneys who are appointed by MCPDS are required to go through and have all of that training and supervision. Attorneys that are appointed through the bench by this bill would only be subject to complaints afterwards. The third thing is, if the committee does decide to go forward with continuing the process of appointments by the bench, I know there have been conversations and there's language here about willingness to accept an appointment, consent to an appointment, but we want to point out the question of the timing of that willingness and the timing of that consent. Because if the appointment is made first, and then the attorney is in the position of saying, well, actually, I can't take the case, now they have to withdraw. So if there's going to be consent and willingness language, whatever it is, it should be in advance of the formal appointment to not put attorneys in a position of having to withdraw. And with that, I'd be happy to answer any questions you may have.
Thank you, Representative Lee.
That last point, is that what's been happening with 1101 in some circumstances, or is that just a potential risk?
So that's my understanding from hearing from members of our committee. I can't speak to it personally, though.
Representative Sinclair.
Good morning.
Good morning.
Do you agree that under the rules of professional conduct, an attorney who is appointed in advance of granting their acceptance of that appointment, they're on the hook essentially until they're able to successfully withdraw, which if the court's having trouble finding an attorney for them may end up being a long span? You agree with that?
Yeah, that has been our concern.
Is that part of the concern you're highlighting for the
Yes.
committee?
Yes, thank you.
Thank you.
And you said it better than I did.
Any other questions? Okay, not seeing any. Thank you for your testimony.
Thank you so much.
Is there anyone else in the room who'd like to testify in opposition to the bill? And is there anyone in the room who'd like to testify neither for nor against? Okay. We don't have anyone on Zoom right now, so I'll close the public hearing on LD 2193. Senator Talbot Ross, would you like to introduce yourself?
I appreciate the opportunity, Madam Chair. My name is Rachel Talbot Ross. Good morning and welcome, everyone. I represent Senate District 28, which is the Peninsula of Portland, the University of Southern Maine campus, and some of the Casco Bay Islands.
Thank you. Yeah. So next up, we'll open the public hearing on LD 2195 and invite Senator Carney back up.
Good morning once again, colleagues on the Judiciary Committee. I'm Ann Carney, and I am presenting LD 2195. This is a bill entitled An Act to Prohibit the Appointment or Assignment of a Private Attorney to Provide Indigent Legal Services without that attorney's consent. This too is a bill that was reported out by this committee pursuant to the law that allows us to report out legislation in response to the PDS report that we receive annually. And again, the committee voted to report it out, not because we had prejudged it, but because we thought it was important to be considered. And so this is the legislation. This bill would prohibit the court from appointing or assigning a private attorney to represent a person who's eligible for indigent legal services unless that private attorney consents to the appointment or assignment of the counsel. And also on the condition that PDS determines that the attorney is qualified to do that representation. And so with that, I'm happy to answer any questions. The director of PDS might be more capable of giving you a detailed answer than I.
Are there any questions for Senator Carney? Not seeing any. Thank you.
Thank you.
Is everyone here in the committee room who'd like to testify in support of this bill?
Good morning again. My name is Rayla Tarpinian. I'm the Executive Director for the Maine Commission on Public Defense Services. Briefly, this bill did come out of our annual report, and I appreciate the committee taking it forward. Briefly, in support of this bill, it's important for attorneys to be able to have some control over their practice in order to adhere to their professional standards of capacity, competence, and conflict checks. One of the issues when an attorney is appointed to a case that can happen is if they're appointed to a case that they have another conflict with. So let's say they are representing somebody already, and that person is either the victim of the next offense or an important witness in that case. If they get that case too, sometimes they have to withdraw from 2 or more cases, and it can cascade through their practice, causing a lot of chaos for clients. Also, there have been a couple of indications and orders that have come out that have caused some alarm within the private bar, sort of indicating that attorneys can be appointed on cases without consenting to take it on. Given that attorneys, this is their work and their practice, it does seem, it's hard to imagine a situation in which an attorney could be drafted against their will to work on a case. And that being said, this was brought forward based on those concerns. We've had a couple times things happened recently. We had an emancipation that was appointed, an attorney from Southern Maine was appointed to a Northern emancipation with no notice and had no idea. He ended up taking the case because he was happy to help out. But he obviously was alarmed, so he contacted our office. So this does happen. It's not a huge issue. It doesn't happen regularly, but it would be helpful to have guidance that was statewide, that all the jurists in the state were aware of, sort of to make sure that everybody is adhering to the same practice standards. And so that's why we're at support. Happy to take any. Oh, I have 2 quick drafting suggestions. One, this was drafted as an 1808 section. There's a provision that's going to go into effect in 1802-B, having to do with employed counsel and public defenders. It may make sense to put this under that because they're kind of similar to each other. That's just a really weedy drafting thing. The other thing is it defines private attorney and it excludes contract counsel. This was intended to apply to people who would be contract counsel. So we would need to insert them in there. It would not apply to employed defenders or public defenders. It would apply to contract counsel. So a contract counsel happens when somebody who's a private attorney becomes appointed on a case and they magically turn into contract counsel, but I think it's intended to apply to both of them. Thank you.
Thank you. Representative Lee?
What's the distinction between public defender and employed counsel?
Technically, many of the central office staff at PDS are technically employed counsel, so I am an employed counsel. And alas, I am no longer a public defender as of October 20th of this year. So different types of attorneys in the same organization is how we distinguish them.
Other questions? Senator Talbot Ross?
Thank you. Welcome. You spoke a little too fast and a little too soft for me to catch all that you said around contract and private. If you could just say that one more time for those of
Absolutely.
us that
Thank
are
you.
old,
I tend to go
that'd be
too.
great.
So an assigned counsel or once an attorney becomes assigned or appointed on a case, they become a contract counsel on a case. Before they are appointed on that case, they are technically private counsel because technically every single appointment is a contract for that case. So your status can change depending on the case, and it's very fluid. But the way we would really divide attorneys would be the employed and public defenders. Those would be internal state employees. And then external would be private counsel, who sometimes are assigned counsel and sometimes they're contract counsel. Assigned counsel and contract counsel are very similar. And we are dancing on pinheads with these definitions. But those are kind of the two groupings of attorneys. So a private attorney becomes contract counsel when they are appointed on a case under the PDS framework. And they are assigned counsel once they're designated by PDS to be eligible to take a case. So one person could be all three of those designations, but it would never be a public defender because that would be an employed counsel on the other side of the house, if you think about it.
Representative Sinclair?
Did you hear the brief conversation I had with Attorney Cohen about the tough situation that a private attorney is put in where the bench might appoint them and yet they find out later they have a conflict, and yet since the court can't find another attorney, they're left on the hook. In light of that, would you object in any way to our inserting the words "in advance" after consents, so that it would read "consents in advance to the appointment," or some similar amendment to make it clear that the attorney's got to say yes before they're put on that hook?
I would strongly support that. There's a lot of chaos both for us and in the clerk's office when we have a failed appointment. That just creates a lot of extra work for everybody. And the conflict situation can become dangerous. I've known of a case in my office where we knocked out 5 clients with an appointment. So it can be, thank goodness that doesn't happen that often, but can be catastrophic to just clients. We had a client post-trial that we had to retry the case and get out of the case. It was really traumatic for that person.
Any other questions? Not seeing any. Thank you.
Thank you very much.
All right, is there anyone in the room who'd like to testify in opposition?
Morning. Senator Carney, Representative Kuhn, members of the Joint Standing Committee on Judiciary. My name is Julie Finn and I represent the judicial branch. And I would like to provide testimony in opposition to LD 2195. The judicial branch opposes the language in proposed section 1808 sub 2 that purports to restrict the court's authority to appoint or assign an attorney under certain circumstances. Judges have the inherent power under the Constitution to appoint attorneys. This issue was reviewed last year under the discussion of LD 1101, and we believe that any outstanding issues can be resolved without further discussion of the court's inherent power. The judicial branch does not object to the parts of the bill involving attorney consent or to the Maine Commission on Public Defense Services providing compensation for only those who meet their eligibility requirements. Again, we are working on an amendment that would incorporate those provisions of this bill into LD 2193, but we would ask that LD 2195 be voted down regardless of the outcome of LD 2193. Thank you for your time. I would be happy to answer any questions.
Thank you. Are there any questions? Okay, not seeing any. Thank you.
Thank you.
Is there anyone in the room who'd like to testify neither for nor against? Let me just confirm there's no one on Zoom.
Okay. Thank you.
Okay, so testimony having been taken, we'll close the public hearing on 2195. We'll open the final public hearing of the morning, which is LD 2194.
Good morning once again, colleagues on the Judiciary Committee. My name is Ann Carney, represent Senate District 29, and I'm very pleased to be with you this morning to introduce LD 2194. This bill is also a bill that this committee voted to report out of committee so that we could consider the topics that are raised by it. And we did that again in response to the issues that were raised in the PDS annual report that we received in January. What this legislation does is it clarifies that in certain instances, when the commission is appointing attorneys, the bill clarifies that when the state appoints a counsel for certain indigent individuals, and it is pursuant to the Sixth Amendment requirement, and that the public defense services is required to pay that person, that in addition, public defense services has the authority to evaluate the qualifications of the person who's appointed, the training, the supervision, and compensation. So, and it is narrowly tailored to 5 different situations. A juvenile who petitions for emancipation and requests appointment of counsel, a child who's the subject of a child protective proceeding, an indigent person who is the subject of an extreme risk protection order under either the so-called yellow flag or so-called red flag law, a person who is the subject of an application for involuntary commitment, and also to represent a non-party witness in a criminal proceeding or civil proceeding when the U.S. Constitution requires that the state provide representation to that non-party witness. And I want to retract something I said at the beginning. It's not crystal clear to me that in each of these 5 cases, the Constitution requires appointment of counsel, but they are all cases at which liberty interests of an individual are to some extent or another implicated. And so with that, I'm happy to answer any questions.
Thank you. Any questions for Senator Carney, Representative Lee?
I'm trying to figure out how to ask this question. So how would this interact with 2193 and or 2195?
That is a good question. I think that each of them raises very important policy considerations. And my suggestion, which I would make at the work session, but I'll make it now since you asked, is that we discuss the policies and figure out which policies we as a committee agree should go forward, and then potentially combine them into one piece of legislation, so long as we're not combining policies that are going to divide votes when it gets to the chambers, because these bills, and particularly the first one we took up this morning, they should be adopted on an emergency basis because they resolve. For years, we've been struggling with this incomplete allocation of who pays for which appointments for people who represent indigent parties in litigation. And this I believe, finally resolves all of those issues. And so we should just agree on the right policy and move that policy or combination forward on an emergency basis.
Any other questions? Okay, not seeing any. Thank you.
Thank you, everyone.
Is there anyone in the room who'd like to testify in support of this legislation?
Good morning, Senator Carney, Representative Kuhn, members of the Joint Standing Committee on Judiciary. My name is Julie Finn and I represent the judicial branch, and I would like to provide testimony in support of LD 2194. Again, referring back to last session, both the judicial branch and PDS proposed bills to clarify the source of payment and statutes where a party or occasionally a non-party has a right to counsel at state expense. These two bills, and in particular LD 1796, which was enacted into law, started a conversation about appropriate payment and funding for attorney services mentioned in other statutes and titles. And there are quite a few of those. To this end, and at Senator Carney's suggestion, a working group met in November of 2025 to discuss these payments with a goal of proposing necessary legislation to effectuate agreed upon statutory amendments. LD 2194 was generated as a result of this meeting and was reported out by the Judiciary Committee in conjunction with the MCPDS annual report. The judicial branch is in full support of the clarifications made in LD 2194. We further, and this is very important, support a fiscal note that provides necessary funding to ensure that attorneys are paid promptly for their services in these important cases. We do have a minor drafting suggestion in section 18024, the last full paragraph. There's a part that describes services provided by an attorney pursuant to Title 22. And that might make more sense as a new subsection, and because the offset paragraph talks about what it does not include, and it might make sense to keep that sort of parallel construction. So maybe that's more of a point for your analyst, but just wanted to point that out to you in my testimony so you have it in writing. Thank you very much, and I'd be happy to answer any questions.
Thank you. Are there any questions for Julie Finn? Okay, not seeing any. Thank you.
Thank you.
Is there anyone in the room who'd like to testify in opposition? All right. Is there anyone who'd like to testify neither for nor against?
Good morning. My name is Freyla Tarpinian. I'm the Executive Director for the Maine Commission on Public Defense Services, and I'm testifying neither for nor against the proposition of 2194. Ultimately, when public PDS became aware of the shortfall, we took some remedial steps to stop paying for cases we previously had paid for in August of last year. That pushed those payments onto the judicial branch, which did not really have a mechanism to do these payments. And they don't exercise oversight or training over the attorneys. A very small example is we typically during the annual Bridging the Gap, which is for new attorneys, do training on involuntary commitments. We chose to continue that training this year, even though we were not paying for the cases, just because it was important that that training continued and that people have introductions to new types of law. We didn't want to interrupt that. So we're neither for nor against, because primarily given our current financial situation, we're concerned if we take these cases back that we need to make sure the funding follows the cases, as the judicial branch put it better than I could. The other thing is there's two slate drafting suggestions, and I don't know if I just committed a cardinal sin, but I drafted it, but I didn't have colorful paper to put it on, so I didn't want to give it to you yet in case you needed that. There's a proposed for new language under section C-1. Section C generally relates to juveniles. B actually relates to adult cases with adults. And so it would make sense to make it a B1, not a C1. This is tiny minutia. And then the second piece is there was a attempt to add in non-party witnesses. We typically think of those as Fifth Amendment counsel. We would be looking for a little bit more, a different language that would limit it to the cases that PDS is responsible for. So we would not support this bill if it made us responsible for all civil actions that has a Fifth Amendment. That could be a very large number of cases, and we do not have the expertise or even the capacity to understand what that responsibility is. And so we have some proposed language just as a proposition that would limit the non-party witness fees to PDS cases criminal cases, protective custody cases, any case that we are statutorily or constitutionally required to uh, provide indigent representation for. And we also put in an eligibility requirement for that Fifth Amendment, for that non-party witness. They would have to be screened eligible for our services. Just those are the two considerations, just trying to put our arms around what that issue was. Our biggest concern, again, is being dragged into a family matter court or a civil action that we have no reason to ever get involved with and no expertise. We try to have some expertise in the subject matter that that we bring representation, and we would have a Fifth Amendment training with attorneys designated to be trained to be Fifth Amendment counsel. We would need to limit that to the subject matter that we are currently responsible for. So that, and I'm happy to provide this, although it's not on colorful paper. It does have some red.
Thank you. I think that's helpful for committee members to be able to see that. Thank you.
And happy to take any questions.
Are there any questions? Representative Henderson?
Thank you, Madam Chair, and hello again. Of these 5 different circumstances, which ones are determined criminal and which ones are determined civil?
So they're all civil unless it's a criminal case. So, and then youth cases are technically housed, so juveniles, we call them youth cases, those would be housed in the district court. So we would consider those, they're kind of quasi-civil in nature. We don't consider them criminal cases. They are distinct in of themselves. So criminal cases are in the UCD, the Unified Criminal Docket. Those are adult criminal cases. They have CR docket numbers. Every other type of case in here are civil. So emancipations are civil, involuntary commitments are civil, protective custody are civil. If we delve into the probate court matters, those would all be civil.
Okay, thank you.
Any other questions? Not seeing any. Thank you.
Thanks.
Is there anyone in the room who'd like to testify neither for nor against? Okay, let me just confirm there's no one on Zoom. Okay, we don't have anyone on Zoom, so I will close the public hearing on LD 2194. And I believe that concludes our work for the morning. And so we will see you back here at 1 o'clock. Thank you.
But the picture of the palace is fine. Yeah.
Good afternoon, everyone. Welcome back to the Joint Standing Committee on the Judiciary. We're going to start this afternoon with the review of a quasi-independent state entity, the Maine Human Rights Commission. And our committee analyst, Janet Stokoe, is going to orient us to what a quasi-independent state entity review is.
Very exciting day with new vocabulary. So you should have a packet prepared by Eli, but being pinch hit by me. So one of the many oversight responsibilities that the legislature has over different portions of the executive branch or independent agencies. Well, there's two major ones. There's the general, the GEA, I think it's a General Evaluation Act, something like that, where different parts of the executive branch are on a cycle and subject to review, and they have to go through a detailed process of reviewing all of their statutes and presenting reports to you. And there's a lot of committees you may have heard of talking about GEA reviews. And like I said, those tend to be departments of the government, like the Department of Health and Human Services, the Department of Public Safety. But there are also entities that are created by statute that aren't specifically within the the executive branch. They are designed by their very nature to be somewhat independent. And this review is sort of a financial oversight kind of review of those independent agencies. And so if you look at the front page of the handout, what is a quasi-independent state entity? So it's an organization that the legislature has established in statute as an independent board, commissioner, agency, and you've established it to fulfill a governmental purpose, and it receives revenues derived in whole or in part from federal or state taxes or fees. And because of those federal or state taxes or fees, you have this financial oversight piece that you've created by law to make sure there's some oversight of the spending of those public resources. So there are some examples here, but listed on the handout, but the example most important to you today is the Maine Human Rights Commission. And that's the one quasi-independent state entity over which the Judiciary Committee has jurisdiction. So what is required of these quasi-independent state entities? So when the statute was originally passed, and that happened back in 2011, and that was due to concerns about some financial spending by a particular quasi-independent state entity. And so the legislature decided, well, let's have sort of a financial oversight of all of them. So back then, the legislature required every quasi-independent state entity to adopt and implement written policies on the procurement and selection of vendors to ensure that the quasi-independent entity gets the best value from those vendors, and to the extent possible, those policies must establish competitive procurement as the standard procurement method. In addition, the law required each of these entities to adopt and implement written policies regarding the use of resources for contributions. And to the extent possible, those policies must ensure that the contributions are directly related to the entity's mission and activities. So you may be wondering, what is a contribution? The actual statute is attached that regulates this financial oversight, and a contribution is defined as a payment for membership dues and fees, gifts or donations, and sponsorships, including a gift or donation or sponsorship that would result in public advertisement of the entity. So for example, if someone in the Maine Human Rights Commission were to have a membership due to a specific, maybe human rights kind of coalition across the country, that might be the type of contribution. As we're going to see from their reports, they don't pay any, but that would be the type of thing that might be contemplated by this law. In addition, the legislature, so in addition to procurement policies, preferring competitive procurement and contribution policies limiting those expenses, each of these entities is also required to have a policy about travel, meals, and entertainment expenses. And to the extent possible, those policies have to limit those travel, meal, and entertainment costs to those that are reasonable and necessary to carry out the mission and activities of the quasi-independent agency. And then finally, why we're here is each of these agencies, including the Human Rights Commission, has to submit an annual report by February 1st to the legislature. And in that report, it must list all the procurements that it had in the last year that exceeded $10,000 and for which it waived competitive procurement. It also has to list all of the persons to which the entity made contributions greater than $1,000 in the preceding year, as well as a description of any changes made in the preceding year to its written policies and procedures, those 3 policies and procedures that you require by statute that to have. And so then, even though these reports are received annually, you are required by statute, or you required yourselves by statute really, to conduct a review in the second regular session and to review these reports that have been submitted and to submit a report to the Government Oversight Committee by March 1st and explaining your assessment of whether the entity's policies are consistent with the requirements of law, whether any reported waivers of competitive procurement were in compliance with the entity's policies, and whether the reported contributions are in compliance with its policies. So that's sort of the overview. If you want to look at the actual statutory language, it is attached. You can see on the bottom of page 1 of that statute that one of the quasi-independent agencies is the Maine Human Rights Commission. That's why we're here today. On the second page of the statutory handout, section 12022 of Title V is the section that requires those 3 types of financial policies to be adopted and gives more detail on what exactly must be included in them. And then on page 3, section 12023 is the requirement for you to conduct a review of those annual reports. And on the back page of that page, subsection 3 is specifically your job. As I mentioned, by March 1st of this year, you need to submit a report to the Government Oversight Committee after reviewing the annual reports and the policies to make sure that all of the things that are required by law have in fact been followed. So then the next thing you have attached is a cover letter followed by the January 3rd, 2025 quasi-independent agency report of the Maine Human Rights Commission. If you remember, they are required to report to you 3 things, and it's not a quiz. So luckily they wrote them out very nicely. So they're supposed to report under paragraph A, all procurements exceeding $10,000 for which they waived competitive procurement, and they have none. They're also supposed to report to you all persons to whom they made contributions greater than $1,000 and the total amount of that contribution. And again, they reported none. And then finally, they're supposed to report to you changes in the preceding year to their written policies and procedures in those 3 areas that are governed by the statute, and they had none. Then if we look, the next is another cover letter, followed by the January 9th, 2026 report. And again, for the previous year, the Maine Human Rights Commission did not waive competitive procurement for any procurement exceeding $10,000. They also did not contribute more than $1,000 to any person, and they didn't make any changes to their written policies and procedures. So those are the 2 reports you have before you. The last page is the rubric for your review. And for that, I'm going to phone a friend from the Maine Human Rights Commission because I only have the copies of the policies issued in 2018 from the last review in 2024. And I had a difficult time emailing. We were getting our paths crossed, but I believe Eli asked them, remember, he put all this together. I believe he asked them to bring the policies with them. If they are the ones from 2018, we can copy them real fast. And we can go through the rubric and you can do your financial oversight of this entity.
Thank you, Janet. Now we are being joined by the counsel for the Maine Human Rights Commission. Could you introduce yourself, please?
Good afternoon. My name is Barbara Archer-Hirsch. I am counsel for the Maine Human Rights Commission.
Thank you. And you were nodding with reference to the 2018 policies. Are those the most current?
To the best of my knowledge, unless someone edited these without telling me, yes.
Okay. So
That's what I brought. So
Thank
I
you.
have nothing newer.
Okay, thank you. And so, committee members, should we just pause for a minute so that we can have copies of those policies? Would that be helpful?
Oh, no, well, those are the individuals, but we also have. Okay, perfect.
So we'll be at ease for a couple of minutes, committee members. And thank you for bringing the documents.
So your stuff should be perfect.
Okay, so the handout you just received on the top are three separate memos from then Executive Director Amy Sneerson from the Maine Human Rights Commission in 2018 about the three different policies. And those are the three policies that they have that are required by statute that we can go through in a second. And then attached to that is a fancier format of those same policies because they've been reformatted since 2018, but it's the same policies in each, is my understanding. So your review is required again to focus on three things. First, whether these policies that they've adopted are consistent with what has to be in them that you've set forth in statute, and then reviewing the waive competitive procurements and the contributions of which there were none. So the end of this review will be very quick and easy. But starting with reviewing the policies, the first is a policy for the selection of vendors, not vendors, which is my typo.
I will never point anything else.
No, I love it. So the policy on the selection of vendors is the top policy that you have. And I gave you the version I had because I already underlined everything and hopefully it will help everyone. So you're supposed to make sure that when they have a policy for the selection of vendors, that they establish competitive procurement as the standard procurement method. I entirely leave to you whether you find that these have been met, but I do want to point out in subparagraph A, it says competitive procurement is the commission's standard procurement method. The second thing you are supposed to check for is that this policy specifies the conditions for waiving competitive procurement. And if you look under subparagraph C, what the Human Rights Commission has done is it's adopted the DAF's procurement policies, which talk about when competitive procurement, I can't say that word anymore, may or may not be waived. So they're adopting the state policies on that particular regard. And then the final thing you are supposed to look for is that the policy has to require written justification for all non-competitive procurements that exceed $10,000. And it has to maintain records to support those waivers for 5 years. And in subparagraph E, it does provide that if there is a procurement exceeding $10,000 that's not competitive, they have to maintain the justification for at least 5 years. So I will look to you to see if those have been met. I did just want to point out the places where I saw evidence that might be sufficient to you.
Committee members, are there any questions either for Janet or for Barbara Archer Hirsch from the Human Rights Commission? And we'll say with regard to that first section. Yes, Representative Henderson.
Thank you, Madam Chair, and good afternoon. I know that we're here to look at contributions that haven't exceeded the $10,000. According to your report, there are none. Are there any that met the $10,000 or were just somewhat below it?
Can I clarify that for just a second?
Of course.
So this part is competitive procurements, and that's the 10,000 limit. And then contributions are slightly different, and that's a $1,000 limit. So I just want to make sure we're going to get the answer to the question you want.
Yes, thank you.
So which question which one do you want to ask? About the
Procurements or the contributions?
So let's start with the procurements because that's where we're on right now, or the competitive.
We have one, $10,000. My name is Michael Whitman, I'm the Director of Operations. We have one contract for $10,000.
Okay.
And other than that, the next highest contract is $8,000 with our mediators.
The mediators, and who's the contract for $10,000 with?
It's for our case tracking software. We used to be with Lighthouse Design. They stopped doing business in 2025. We are currently working on drafting a new contract with JMA Consulting that will continue to support our case tracking software, which is called City.
But we didn't
CIVI.
we didn't waive
We
the
didn't have to.
competitive
That's right.
procurement for that.
Right, because it didn't exceed the
It did exceed
$10,000.
$10,000. That's correct.
Okay, thank you.
Any other questions, committee members? Thank you. Committee members, I'd like to do a straw poll since I think we've completed the first section of this rubric. And so for those committee members, does any committee member feel that the requirements in 12.022.3 have not been met? If you think they've not been met, can you just please raise your hand and articulate your concern. So I'm not seeing any of those who feel that they have been met. Please raise your hands. So that straw poll indicates yes.
Okay, the next policy that you are to review is the policy about contributions. And I just want to remind you of the definition of contribution because it's a unique type of expenditure. So under statute, this type of contribution means a payment for membership dues and fees, gifts, donations, and sponsorships, including those that result in public advertisement of the entity. So you are required to ensure that the policy states that contributions have to be directly related to the entity's mission and activities. And I underlined a line in the first paragraph, and I believe that there is a similar line in the second paragraph, although it's not underlined.
Thank you. Any questions about that, committee members? Seeing none?
The next thing to review is that the policy provides that contributions should be budgeted and accounted for separately from other expenditures in the entity's records. And subparagraph D appears to be responsive to that requirement.
Any questions on that one, committee? Seeing none?
The third statutory requirement is that the policy has to require documentation to be maintained to support each contribution. And I believe subparagraph C is perhaps responsive to that requirement.
Questions or concerns about that, committee members? Seeing none?
And then the last thing that has to be included in the policy is that the governing body must be required to approve an annual budget specifically for contributions, and it has to be given periodic reports on contributions made by this entity. And I believe subparagraphs E and F may be responsive to that requirement.
Thank you. Committee members, any questions for Janet or for Barbara Archer Hirsch? Representative Henderson?
Thank you, Madam Chair. So I guess I'll go with the same question for this one as well. Nothing that would have exceeded $1,000. Is there anything that met the $1,000 or kind of within that space?
Not that I can think of. The closest that we would come, I would think, is the commission pays for 3 of us to be licensed attorneys now because 3 of us are required by statute. I don't know what the total is. If you add up the 3 memberships, I believe it comes in under $1,000, but it might get close. The only other expensive thing I can think of is our membership to IORA, which is several $100s. That's the International Association of Human Rights Associations that the commission has been a member of for years, and we pay annual dues.
You said that's within just a few $100s. Okay, thank you.
Any additional questions, committee members? Yes, Representative Lee?
Just a question for Janet. In the statute, would those separate expenditures for, say, a membership in the bar or keeping your license up, would those be individual expenditures which can't exceed 1,000 or cumulatively?
I think you could read it either way. I think that Attorney Hirsch is reading it more conservatively to combine it to see how much money was spent toward one entity, and that would be the Board of Overseers. So
Thanks.
I think it's the best way for you to have oversight with that transparency.
Any additional questions, committee members? Does any committee member have a concern about this criteria being met? If so, can you just raise your hand and articulate them? Not seeing any concerns. All committee members who feel that this criteria has been met, please raise your hand. Appears that, and Senator Albert Ross, are you?
I'm just trying to keep up.
Okay.
You're still taking a straw?
Straw poll?
Yeah.
Okay. So it appears that, Representative O'Halloran, did you also raise your hand? Okay, okay. Thank you, everybody.
Then, in this part of the review, the last policy to be reviewed is the policy on travel and meal expenses. And just in full clarity, there is allowed to be a policy for payment of travel, meal, and entertainment expenses. But the Human Rights Commission has taken the position that it will not reimburse for any entertainment expenses. That's in the middle of the second paragraph. So this policy is only about travel and meal expenses. I don't view that as deviating from the requirements. They just aren't going to pay the other one, so they don't need any rubrics for payment of those expenses. So as far as the travel and meal expenses, by statute, the policy must limit these costs to those reasonable and necessary to accomplish the entity's mission and activities. And I believe there's language in the first paragraph that is responsive to that requirement. Seeing no questions, I'll keep going. The policy must also specify for whom the costs will be paid and the conditions under which they will be paid, and whether they will be paid directly or through reimbursement. So if we look at the bottom of the second paragraph, it says that the travel and meal expenses would be paid for an employee when they're conducting business of the commission under certain conditions. And those conditions are set forth. And then if you look, it says in subparagraph D that whenever possible, the commission would advance the amount for travel and meal expenses. But if it's not possible, then you can seek reimbursement.
Any questions, committee members? Seeing none, thank you.
The next thing that has to be in the policy is that it must set requirements for supporting documentation and approval of these costs. And I believe subparagraphs A and B are responsive to that requirement.
Any questions, committee members? Seeing none?
Then the policy must require that these costs be budgeted and accounted for separately from other expenditures in the entity's records. And I believe subparagraph A is responsive to that requirement. Sorry, F. Did I say A? I don't know why. F.
Thank you. Any questions, committee members? Seeing none.
And then the last statutorily required component of this policy is that it must require the governing body to approve an annual budget specifically for these costs, separate from everything else that's budgeted, and also be given periodic reports on actual costs paid directly or reimbursed. And I believe subparagraphs G and H are responsive to that requirement.
Thank you. Any questions, committee members? I actually have one for you. How frequently are the periodic reports of actual costs presented to the commissioners?
Yeah, those would go in our quarterly financial reports, which Michael puts together and we give to the commissioners.
Thank you. Are there other questions, committee members? Seeing none, does any committee member have concerns about this criteria that you wish to raise? I am not seeing any. All those in favor of determining that that criteria has been met, please raise your hands. That is unanimous with one abstention.
Okay, so the last aspect of your required every 2-year financial oversight of the Maine Human Rights Commission is to check whether all waivers of competitive procurement that were reported in the past 2 years were in compliance with the entity's policies and procedures. And you have reports stating that there were none.
So show of hands on checking that not applicable. Thank you. And with one abstention, Representative Henderson.
Yeah, I'm sorry, I didn't catch that part.
So we're on the second to last part of the analysis. And Janet had indicated that there were no waivers of competitive procurement reported in the last 2 years. And so my suggestion was that we complete that not applicable. And so all those in favor of doing so? That is unanimous. Thank you.
And then also you are to assess whether all reported contributions were made in compliance with their policies and procedures in the last 2 years. And again, you had no reported contributions in the last 2 years.
So again, I would suggest that we complete that not applicable. And if you are in agreement, please raise your hands. Yes.
I want to make sure I'm understanding this correctly. Were all contributions made by entity and reported in the last 2 years in compliance with the policy and procedures?
Right.
Are they saying that they didn't receive any contributions?
No, these are contributions made. So your oversight is of the the public resources given to the Human Rights Commission and what they spend those public resources on,
Right.
and they're required to report any contributions over $1,000. And then you're supposed to assess whether those reported contributions were consistent with their policies and procedures. And they reported none that were over $1,000.
So I guess my question is, should it be non-applicable or should we say, yes, they're within compliance? Because they're within, the contributions are made in the last 2 years are in compliance with the entity's policies and procedures. So therefore it is applicable.
I think we can get around that. I can show you the report you sent last time. And you just said there weren't
There weren't any that
exceeded.
exceeded it, but they're still within the compliance. I see you nodding and pointing.
Okay. Representative Lee?
I'm loving the pedantic way in which you're dealing with this question, because I can see what you're saying, right? The way that the previous question was worded, were all waivers of competitive procurement. That's obviously not applicable because there were no waivers. This one is just worded, were all contributions compliant, rather than were all contributions in excess of 1,000.
Right.
That's because it's an artfully written question. If you look above, the actual quote is whether the reported contributions were in compliance, and there were not.
Right. So if the question were worded correctly.
So not
It would
only
be
is there a
not
typo, there is a question worded incorrectly on this 8-year-old chart I made.
Does
I think I
anybody
made
need a
it here.
corner caucus on this?
I will deduct from my salary the appropriate expenses.
Representative Henderson.
I just want to make sure that my vote reflects accurately what my understanding of the question.
All right, so I'm going to rephrase the question so that we can attain unanimity. So I'm going to reframe the question by saying were all reported contributions. Well, were all contributions over $1,000 made by the entity and reported in the last 2 years in compliance? And so for those who are in agreement with that, please raise your hands. And that is unanimous. Thank you.
So you can imagine that maybe the Human Rights Commission isn't who this statute is really targeting. But I leave that to you to decide another day. I did want to show you the report that you sent to the Government Oversight Committee, or that this committee sent 2 years ago. And it just said basically that you found that the policies that they've adopted were consistent with the expectations in statute, and that there weren't any reported procurements exceeding $10,000 for which competitive procurement was waived, and no contributions exceeding $1,000 reported. So that it doesn't really get into whether it's consistent or not, just explains that there weren't any. So that part isn't necessary of the review. So if you're okay with it, your report may look eerily similar to this.
So let's do a vote so that when the eerily similar report comes back, we can simply treat it with more of a language review type approach. But so is there a motion to indicate on the that the Maine Human Rights Commission has complied with, well, would somebody like to make a motion and they can figure out how to wordsmith it? Yes, Representative Kuhn.
Thank you. I would move that we report to the Government Oversight Committee that the Maine Human Rights Commission is in compliance with 120223 and 120224 with respect to the policies they have in place, and also 120225, and that there were no waivers of competitive procurement or contributions over $1,000 during the reporting period.
Beautifully stated. Thank you. Is there a second? Second by Representative Sato. Is there any discussion of the motion, committee members? Seeing none, all those in favor, please raise your hands. And that is unanimous of those present. Thank you.
Thank you very much. I want to say a special thank you to Janet and Eli and Absentia for getting me through this. I'm not allowed to touch the money for reasons that would be painfully obvious if you knew me better. So they and Michael got me through this, and I just wanted to say thanks.
Thank you very much. Committee members, we're going to be at ease very briefly in order to prepare for our final public hearing of the day. Good afternoon again, committee members. We're going to open up our final public hearing of the day. It's on LD 2207, an act regarding the statute of limitations for certain sexual offenses committed against minors. And it is being presented by our colleague, Representative Kuhn.
Thank you, Senator Carney, esteemed colleagues. This is a bill that the committee reported out in response to a report we received from the Criminal Law Advisory Committee. It would implement two recommendations from that report, which involve eliminating the statute of limitations for prosecution of sex trafficking of a minor or someone who was a minor at the time of the crime, and commercial sexual exploitation of a minor. I would note that the committee did not and has not taken a position on this bill, but rather we agreed to put it forward as a bill so that it could receive a public hearing. That is all I have for you.
Thank you. You may return to the horseshoe.
Thank you.
Is there a representative from the, excuse me, representative from the Criminal Law Advisory Committee who wishes to speak with regard to this legislation?
Good afternoon. I do not have prepared remarks. I'm really here as a resource in case anyone on the committee has questions. So I can speak to the bill or I can just stay quiet until you wish me to speak.
Thank you. I appreciate that offer. And I was looking at correspondence from someone other than Clack, and that is why I was stumbling with the Clack name. But thank you for being with us. And let's just see if committee members, are there any questions? Yes, Representative Lee.
Clack submitted a letter on January 6th, I think responsive to a different bill, which I think this bill is the genesis of those questions of unifying statutes of limitations, or am I misunderstanding?
I'm sorry, are you referring to the report that we submitted on statute? Yes, yes.
And so this piece of legislation is responsive to those suggestions that Clack made?
To the report from the Criminal Law Advisory Commission.
Right.
The one question, I guess, that we raised in the report that's not addressed in this legislative proposal is where you added commercial sexual exploitation against a minor. That statute actually addresses commercial sexual exploitation of minors and persons with a mental disability that's readily apparent or known to the actor. So the only question I was asked is whether or not the committee had considered adding that. And that is an issue that we raised in the report, but I didn't know if the committee wanted to go there or not.
And so that would be on page 1 of the bill in line 7.
It depends on whether or not where you want to add it. So the statute, commercial sexual exploitation of a minor or a person with a mental disability, there are two separate provisions depending on the victim. You have added half of the statute, and it's section 855 in Title 17A. You've added the portion that includes offending against a minor, which is consistent with the statute of limitations now for eliminating the statute of limitations with respect to most sex crimes against minors. So the question is whether or not you want to take that other part of section 855, which is commercial sexual exploitation of a person with a mental disability that's readily known or apparent to the actor, And that prevents the victim from being able to appraise the nature of their conduct and understanding that they can consent or not. Do you want to add that to these special categories where there is either no or an extended statute of limitations? If you view that victim as being the same type of victim as a minor child who needs that extended protection forever, you would add it to section 1. If you want to add it to the 20-year statute of limitations, you would add it to section 2.
Thank you. That does clarify it. And I just wanted to note, committee members, that if you look at the, I think this is called Goldenrod, the third page of the Goldenrod handout, you'll see the 2 different definitions within commercial sexual exploitation. The first paragraph 1 is of a minor, and paragraph 3 is a person with a mental disability.
It's also in your books. If you have your books, it's section 855, I believe. Yes, section 855. Most of the crimes against a person, most but not all of the crimes against a person with a mental disability, the sexual assaults, are already picked up in the 20-year category because they are A, B, or C crimes involving unlawful sexual contact, gross sexual assault. So a lot of them are already picked up. This is kind of an outlier.
And so, committee members, if you're looking at your statute books, it's page 128. And so to be consistent with the existing structure of the law, it would be appropriate to add the reference of a person guilty of sexual exploitation of a person with a mental disability to the 20-year category rather than to the waiver of any statute of limitations.
I think that's your policy call, how you
Right.
want to treat that category of victim as the 20-year or complete elimination of the limitations period.
Understood. I think my question was a little bit different. It was more about the status quo. So in other instances, is the abrogation of any statute of limitations limited to minors?
Yes.
Okay. Thank you. Other questions, committee members, Representative Lee?
I think the other end of that question, just to make sure I'm understanding, other sex crimes dealing with a person with a mental disability are in the 20-year category?
They're treated as other crimes against adults are treated. So if it's an A, B, or C crime within the listed categories of that 20-year paragraph, which I believe are gross sexual assault, unlawful sexual conduct, aggravated sex trafficking, then they're in the 20-year category. So yes, most crimes against a person suffering from a mental disability, most sex crimes are in the 20-year category.
And the reason Clack was pointing this one out is because it's inconsistent with those since it's treated as sex.
Yes. Okay. And because some of the same policy considerations may apply to that category of victim in terms of delayed disclosure and if the legislature wants to protect that category of victims for a longer period of time. There are a lot of policy issues that come into play there. So we didn't take a position as to whether or not you should do it, just brought it to your attention.
Yeah, thank you. Other questions, committee members? I'm not seeing any. Again, thank you for being with us today and for your explanation.
Sure, and I apologize for the informality of my comments. I didn't plan to speak, just be here just in case.
Well, you honed right in on the things that we were concerned about. Thank you.
Thank you.
Is there anyone else present in the committee room or anyone present in the committee room who wishes to speak in support of this legislation? If so, please step forward.
Good afternoon, Senator Carney, Representative Kuhn, and members of the Joint Standing Committee on Judiciary. My name is Carly Fisher, and I'm offering testimony today on behalf of the Maine Coalition Against Sexual Assault. Mikasa is here today in support of LD 2207. Thank you to Representative Kuhn for sponsoring this important legislation. This bill represents a logical next step in the legislature's ongoing work to ensure Maine's statutes of limitation reflect both the seriousness of commercial sexual exploitation of children and the realities faced by minor victims. Commercial sexual exploitation of children, I'm going to say CSEC from here on out, is an umbrella term that includes sex trafficking and other forms of abuse in which sexual activity with a minor is exchanged for something of value. Under Maine law, aggravated sex trafficking and commercial sexual exploitation of a minor are two crimes that fall within this broader CSEC category. In the first session of this 132nd legislature, the statute of limitations for aggravated sex trafficking was extended to 20 years through Public Law 2025, Chapter 479. That change was an important step towards accountability, but it highlighted an inconsistency in Maine law, which already eliminates the statute of limitations for several sexual offenses committed against minors, including gross sexual assault and comparable crimes, while aggravated sex trafficking and commercial sexual exploitation of a minor remain subjected to time limits. Recognizing this disparity, the legislature directed CLAC to review statutes of limitations for sexual offenses, including whether extended limitation periods should apply to additional crimes. LD 2207 reflects the finding of that review by aligning aggravated sex trafficking and commercial sexual exploitation of minors with Maine's existing approach to other sexual offenses against youth. Treating CSEC differently than other sexual crimes creates an arbitrary distinction that this bill corrects. Further, an extended statute of limitations benefits survivors because delayed disclosure is the norm, not the exception, in cases involving sexual mistreatment of minors. Survivors of CSEC often face coercion, manipulation, threats, and profound trauma. It can take decades before a survivor is able to safely disclose what happened, and even longer to seek justice and accountability. A statute of limitations can close the door to justice before that disclosure is possible. This bill also presents an opportunity to ensure parity for other populations that are targeted for commercial sexual exploitation at disproportionate rates, including individuals with intellectual and developmental disabilities, or IDD. Maine law already recognizes the seriousness of these harms by explicitly referencing persons with mental disabilities in the commercial sexual exploitation statute. When the criminal code identifies the population within the elements of an offense, it reflects a legislative determination that the harms they face warrant meaningful protection. Extending the same statute of limitations framework to these survivors would promote consistency in the public law, changes under consideration, and ensure protected populations are treated accordingly. Eliminating the statute of limitations does not guarantee prosecution or conviction. It simply ensures that when survivors are ready to come forward and evidence supports the case, the justice system can respond. This change would align Maine law with its existing principles by affording youth and people with IDD who are trafficked or commercially sexually exploited the same opportunity for justice as victims of other serious sexual crimes. For these reasons, we strongly support the bill. Appreciate your consideration and would be happy to answer any questions you may have.
Thank you very much for your testimony. Committee members, are there any questions? I am not seeing any. Thank you. Is there anyone else present in the committee room who wishes to speak in support of this legislation? Seeing none. There are none. So one online. Is there anyone in the committee room who wishes to speak in opposition? Please step forward. And finally, is there anyone in the committee room who wishes to speak neither for nor against? If so, please step forward. Seeing none, we will close the public hearing on LD 2207. Committee members, I think we should consider whether we want to move immediately to a work session and vote on this proposal. And I would just ask if committee members wish to take a short caucus break before we decide whether or not we want to take that step, or whether we're ready to make that decision now. Let's take a little caucus break and be back at approximately 2:05, everyone. Thank you. Everyone, welcome back from our caucus breaks. I know we had completed the public hearing on LD 2207, and we were spending some time thinking about whether we felt ready to move into a work session on this bill. And I'd just say that I think we should take a little bit more time and think this over before we move on for a work session, and we'll also be able to have the legislative analysis, which I think will be helpful to all of us. And so at this point, I believe we're completed with our work for the day, unless there's language reviews or anything else for us. All right, then our work on LD 2207 is complete, and our day is also complete. We have legislation tomorrow, 2 public hearings, starting at, I believe, 10 and at 1. And so with that, is there a motion to adjourn? Yes, Representative Sato.
I move to
Sorry.
adjourn. Oh, sorry. I move to adjourn.
Is there a second? Second by Representative Pugh. All those in favor? We are adjourned.